Hey everybody, welcome back to another edition of Freedom Steel. Todd Vandermite, former NRA contract lobbyist and Illinois gun law guru. So this is a video I've had on my mind for a while. It deals with one of the topics that I've been putting together in our challenges to the Illinois prohibition on semi-autos, parts, and whatnot. Before we get into all that, a couple of things. Quick shout out to Vanilla Gorilla VGS. I'm wearing my VGS shirt as an alumni. Ben Wallach's teaching. Evidently, I threw an extra consonant into his name in some of my previous mentions of him, thinking he was Polish or something else. And evidently my public school math is showing through because he was a member of SEAL Team 2, not SEAL Team 3. I guess those East Coast guys don't like to be associated with the Hollywood guys because evidently they don't get the book deals. But that, and don't forget that Aurora Sportsman's Club Zombie Shoot is coming up here rather quickly. September 9th. You can get tickets at the link down below. Please come on out. It's a good time will be had by y'all. Flip the middle finger to the governor and his cronies and the follically challenged foreskins and come out and enjoy all the toys they just hate for us to have. So with that, let's get into this. So the title of this video is The Right to Repair. And this is something that has come about through my work on the FFL case and on some other legal memos as we try to figure out how to get into protecting this. And it's not a complicated theory, but as some of you know, I'm involved with the Second Amendment Law Center that's out of California, sit on their board. I'm also involved with the Second Amendment Defense and Education Coalition, SADEC. You'll find links to both of them below. And what I want to talk about is, to my knowledge, we're the only groups that are talking about this concept when it comes to litigation. And the Second Amendment Law Center was founded to help fund all kinds of litigation, and it's made up of a lot of small donations because they don't have some sugar daddy behind them. And SADEC was formed here in Illinois because we wanted to have more of a say, more of an input into what was going into the briefs and the legal action, because we were less than happy with the way we had seen a lot of things argued before the courts, and we felt that there was a lot left on the table, and there was a lot more that could have been argued to advance the ball farther down the field. So with that, I will have their links below. I encourage you to make whatever contribution you can to these groups because they are going to be, fighting for the things that I think are important from the standpoint that we're going to have ways to advance the right. So let's think about this, as if it's a football game. You know what? Those Hail Mary touchdown passes, great. But, it's those drives where you keep moving the ball down the field 5 yards, 10 yards at a time, and you keep marching until you get down to the goalposts. And we're not really here to kick a field goal. We're here to get into the end zone with a touchdown, and that's what this is all about. So if we go back to 2008, we had the Heller decision. And the Heller decision said that the right to keep and bear arms, and they split those out as being two distinct individual things, fell under the individual rights protected and announced under the Second Amendment. We already had that right according to them, but the Second Amendment just codified a restriction on governmental intrusion into that right. 2010, the McDonald case sat there and was challenged. There was a second case to that brought by the NRA. And with that, the Second Amendment was incorporated via the 14th Amendment to apply against state and local governments. So now, let's jump forward here to last summer where we had the Bruin decision, or New York. I like to call it New York because it was New York State Rifle and Pistol Association versus Bruin, who was the Attorney General of the state. And we are here because, I don't think we should be naming the losers. We should be naming the winners. And the winners were New York State Rifle and Pistol Association. I shorten it to New York. And just so y'all know, I'm drinking out of my zombie cup tonight to keep promoting the zombie shoot coming up on September 9th. So here, in the decision, here's what the court said. We reiterate that the standard for applying the Second Amendment is as follows. When the amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. So here is the conduct. Does the conduct fall under the Second Amendment? Well, let's take a little trip. So we had Keep and Bear, Ezell, and McDonald that were both found to be conduct and Heller threw out any interest balancing, although the courts didn't bother to listen to that for 13 years. But then let's make a little jump over here. So 2010 was McDonald. But let's jump up to 2011 in a case called Ezell v. Chicago. So Chicago had put in a ban on ranges. And in that, they sat there and said that you had to have a new Chicago firearms permit in order to own a gun. Part of that was you had to go to a range and show competency with a firearm, but we're going to outlaw ranges in the city. You can travel outside the city. And the Court of Appeals, now the lower court found in favor of the city, happened to be the same judge that found in favor in Naperville, who was then reversed not once, but twice, because Ezell made it up to the Court of Appeals twice. But this is the first Ezell case taking place in 2011, a year after incorporation by the Supreme Court in McDonald. So here, they said the right to possess firearms for protection implies a corresponding right to acquire and maintain proficiency in their use. The core right wouldn't mean much without the training and practice that make it effective. Several passages in Heller support this understanding. Examining post-Civil War legal commentaries to confirm the founding era individual right understanding of the Second Amendment, the court quoted at length from the massively popular 1868 treatise on constitutional limitations. To bear arms implies something more than mere keeping. It implies the learning to handle and use them. It implies the right to meet for voluntary discipline in arms, observing and doing so the laws of public order. No doubt, citizens who keep a gun or pistol under judicious precautions practice in a safe place the use of it, and in due time teaches his sons to do so the same exercise his individual right. All right, quoting Benjamin Vaughan Abbott, judge and jury. There's a long citation there. So, what do we have here? Well, Heller said keep and bear. But New York said any conduct that falls underneath the Second Amendment is presumptively protected. It's then the burden on the state to say otherwise. So here we go. We come down. Ezell said that, but Ezell said just a little bit more. It noted in that passage not only the right to maintain proficiency, the right to train, but the right to acquire. We've heard Kwame and company argue ad nauseum there's no right to sell guns. I disagree. If there's a right to acquire firearms, there has to be a corresponding right to sell. So we have the right to acquire, we have the right to train and practice. Okay, now let's skip forward just a little bit more, because here we are in 2014. In the Illinois Association of Firearm Retailers versus the City of Chicago, the Circuit Court of the Seventh Circuit, not the Court of Appeals, but the District Court there, talked about the right to acquire, and this was about the ban on gun shops in the city. Indeed, this reasoning makes sense because if all cities and all municipalities can prohibit gun sales and transfers within their own borders, then all gun sales and transfers may be banned across a wide swath of the country. If this principle is carried forward to its natural conclusion, therefore, just as where the fact that residents may travel outside the jurisdiction to fulfill training requirement, it is irrelevant to the validity of the ordinance inside the city. And they said the gun ban on gun sales and transfers prevents Chicagoans from fulfilling within the limits of Chicago the most fundamental prerequisite of legal gun ownership, that of simple acquisition. So now, protected by the courts, we have the right to acquire and the right to sell. Okay, so if we have the right to acquire, the right to sell, we have the right to train and maintain proficiency. Well, Kwame and company have been using militia laws against us in a number of court cases and citing them in order to say, see, these types of regulations, these types of laws, this is the historical relevancy. Okay, Mr. Attorney General, let's jump over and see what you've cited. So what the anti-gunners have typically cited are the militia laws. And here's a quote from the Gun Owner Privacy and Second Amendment paper written by Megan Walsh, who leans on the other side. Quote, governments routinely required those serving in the militia to present their weapons for inspection and to appear in public to train with their arms. New Jersey 1778 session laws provided that a sergeant would enter the homes of militia members to inspect their arms every 4 months. South Carolina 1790 militia law required able-bodied men to appear at muster and have their weapons evaluated. Participants were fined if their weapons were not available. In 1799, Kentucky law required inspection of weapons at muster, and inspection of weapons there. Militia officers were required to report on the available arms in their command to pass, command to assess the strength of available weaponry. The official manual for the U.S. Army and many state militias from 1779 till the War of 1812. Let's see, there's a long cite in here. Required daily inspection of weapons for those in service, and provided that those who had lost, sold, or damaged their weapons be fined. So what do we have here? The takeaway from here is that we have a right to train with our firearms. How can we train with firearms if they're not in good working order? Here, the militia laws of the turn of our country, around the signing of the Bill of Rights, clearly wanted individuals to show up with well-functioning firearms in good working order. Well, how do you keep a gun in good working order? You do so by parts and maintenance. Therefore, the parts ban that they wrote into subpart I of section 24.1.1, I think, is unconstitutional on its face. But here's where the right to repair starts to build up a little bit of steam and helps us with other things. So we have the right to keep and bear, we have the right to train. If we have the right to train, then we therefore have to have the right to keep our firearm in good working order. If we have the right to keep our firearm in good working order, we have to be able to acquire parts, just as we acquire firearms. But then, let's take it a step further, because at the time of the founding, in 1791, when the time the Bill of Rights was drafted and codified, the majority of firearms were being imported or made from small companies, blacksmiths, the like. The infamous Springfield Army of Lore didn't really start making muskets till after 1791, well after the Revolutionary War. They're primarily making cannons prior to that. So here we have it, that if we have the right to repair our firearms, don't we have the right to assemble firearms? If we can amass all the parts, if we can get the receiver, the barrel, the breech, if we can get the stock and the trigger and all those kinds of things together, do we not have the right to assemble a firearm? We have the right to acquire it. Why, if we can acquire the parts, then we naturally have the right to assemble a firearm. If we have the right to assemble a firearm, then don't we have the right to build a firearm in our own home? If we have the skill and ability, whether it be through the machines or just ingenuity to engineer one, and we have the means to pick up a file, run a lathe, run a mill, whatever it is, and build a firearm. Why isn't that a right? So now we go back to what the court said in New York. If the conduct falls within the text of the Second Amendment, it is presumptively protected conduct. And the burden flips. It's not our burden to say we can do this. It's the state's burden to prove that we can't. And I don't think they can meet that burden. So here, the right to repair actually is a stepping stone to going after all the ghost gun laws that they have for all the home-built firearms and all of that stuff. Now, I know that there's a challenge in the Fifth Circuit down in Texas over the frame and receiver rule, which is really about the so-called ghost guns. But that's a challenge to the Administrative Procedures Act, unless we get a little lucky, and it would be very nice if that court also kind of ruled on the Second Amendment challenge down there a little bit. But I'm not expecting that. But if we win this right to repair, it is the building block, it is the stepping stone to undoing all this stuff on home-built firearms. And that's where New York becomes the key, because if we can get the lower courts to agree that this conduct is protected. We already have a Zell saying acquisition and training, which that kind of dovetails into the new marketing law that they've put forward. So with all that, that's the right to repair. That's why the right to repair. That's why when FFL Illinois filed their lawsuit in Southern Illinois, they didn't tackle magazines. We thought, everybody involved in that lawsuit thought that magazines was going to be such an argument about whether or not they're components, whether or not they're arms, whether or not they're this, whether or not they're that. All that would take a suit unto itself. All the other groups wanted to throw guns and mags together, and they kind of just glossed over the attachments and or parts. And to me, if you want to do really constructive litigation, you win this fight, because if we win this fight, it leads to decimating a bunch of the other stuff they really want. To me, it is the foundational pier that does away with the home-built stuff at the bans like Illinois passed, not the ATF rule, because that's an Administrative Procedures Act challenge. That's very different. But under the Second Amendment, under the conduct that's protected under the 27 words of the Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. How can I keep and or bear an arm if it's not in good working order? If it's in good working order, then I must have the right to acquire the parts to repair it, to make sure it stays in good working order. Barrels wear out, springs wear out, bolts break, things like that happen. And if I naturally have the right to repair my firearm, then the next two steps I outline naturally flow from that. And they all become conduct that is protected by the Second Amendment, with the burden on the state to refute that. And I don't think they can. So, guys, that's the right to repair. That's why we are arguing that in Southern Illinois. That's why it is so important to get this in there. That's a fight. And I don't see anybody else making those arguments. So here, running just a hair long, but want to say thank you very much To all our supporters, please like, subscribe, copy and paste the link to your social media. Get this stuff shared around. We're knocking on 10,000 subscribers. We really want to break that. We'll be on to the next goal. We really appreciate all the shout outs we've gotten from guys like Instructor Mike, KB32, and the other guys. So, as always, thanks for your support and frag out.